How you doing?
Hello.
Fine. You know what? There was a chair sitting right outside the door.
Yes, sir, I got it right here.
Oh, okay, thank you. He's got it. He's smart.
Okay, good.
Thank you.
And
Good.
what is your name?
My name is Maris Ray James.
Thank you very much, Mr. James. Give me 1 second and we will call your case here in just a moment.
Okay.
Hey, everybody, while they're doing that, I'll go ahead and just say, hey,
All right,
welcome to
thank you for
American
your
Courts.
patience, sir. You are Thalmers Ray James.
Yes, I am.
Mr. James, your date of birth is April 15th, 1954.
Yes, it is.
Thank you. Mr. James, you're before the court this morning because you have been charged by way of criminal complaint by the city of Lakewood under case 25L000460 with 1 count of theft in the 3rd degree. Ms. Arnold, are you prepared to proceed with Mr. James's arraignment at this time?
Your Honor, I will need to have a breakout room very quickly. I just have one question that I need to be answered.
Okay. Mr. James, we're going to put you in a breakout room. Officer, Mr. James may need some assistance getting into the breakout room.
Fine, Jess. Thank you.
Thank you.
Your Honor, Ms. Horwath just answered that question for me, so I believe that we can proceed.
That's even better.
Okay. Ms. Arnold, if you're ready to proceed, go ahead.
Yes, Your Honor, this is Sophia Arnold, present here today with Thalmer James. Defense will waive a formal reading and ask the court to enter a plea of not guilty and stipulate to probable cause for today's purposes only. After screening the defendant, he does qualify for court-appointed counsel. Oh, 1 second. Ms. Horwath is actively typing. 1 second.
I see on the screen.
He does qualify for court-appointed counsel without a promissory note, and we ask to be appointed to his case. Thank you.
Thank you very much. Mr. James, based on everything that Ms. Arnold just shared with the court's going to waive formal reading. The court does find there's probable cause to support the charge and will enter a plea of not guilty for you at this time. I'll next hear from Mr. Graham regarding the prosecutor's recommendation on pretrial conditions of release.
Yes, Your Honor. City is recommending a release on personal recognizance with no law violations and to stay away from Safeway.
Thank you very much. Ms. Arnold, any response?
No objections to that, Your Honor.
Thank you.
Can I ask one question? Because is that
Wait,
Safeway?
can you not? Oh, go ahead.
Yeah, I need to know that. Is that every Safeway or is the Safeway that is addressed?
At this address.
Okay, thank you. Important to know.
So, Mr. James, thank you for that clarification. The court is going to follow the agreed recommendation of the attorneys. I'm going to release you on your personal recognizance, so you should be released from custody later on today. The court is going to impose some conditions on you, though.
Yeah.
The first condition the court's imposing is you must appear in person and on time for all scheduled court hearings. Your next hearing in this matter is going to be March 25th at 2 p.m. in the afternoon. You are required to be here in person and on time here at the Lakewood Municipal Court. You're also required to stay in
Excuse me.
Yeah.
You said Lakewood Municipal Court, that's in the town center, right?
Yes, sir.
Okay, great. Fine, I can make it there.
You bet. The next thing the court's going to do is appoint Ms. Arnold to represent you as your attorney in this case. You need to remain in contact with Ms. Arnold. Her contact information is going to appear on the paperwork that you'll be receiving after your hearing today.
That'd be great.
The other conditions the court's going to impose is you can have no criminal law violations. You need to update the court if your address changes. You have to use only your true legal name and date of birth, and you can have no contact with the Safeway store off Gravelly Lake Drive in the city of Lakewood.
Okay.
Sir, those are all the conditions. I've signed that order. You'll get a copy of this from the officer. You can go ahead and let the officer know that your hearing is all done. We'll see you back here on March 25th.
Okay, thank you, Judge.
Thank you.
You know, I go on April the 1st, I go for my,
Mr. James, could
can I
you,
say this? It's important to me, and I am a person I can talk. I'm 71.
I'm just making sure, Mr. James.
I won't say the wrong thing. Just April the 1st, I start school for my PE. I'm going to get me a doctorate in health administration. I have worked a long time for that. And yes, ma'am, I understand, but I want people to know what I'm
I
going
was
to be
making
doing.
sure you didn't
Thank
state
you.
anything that could hurt you.
I have 71. I know the courts and I respect the judge and you, but I still have my own say.
Okay, thank you, Mr. James.
So you ready?
Yes.
I'll go ahead and hit mute. That guy there, was giving a hoot. He wanted to make sure it was known what he was going to go to college. He was going to be a hospital administrator? I'm not sure. I think he said he was 71. He's getting ready to go to college, so I guess it's never too late. Got some court clips for you guys tonight. Got Judge. We'll go ahead and knock out the Judge Boyd one. It's good. She calls the woman's bluff, says, "Hey, let's just go ahead and pull up the tape on it." So here we go on that.
All right, we're ready on your client. If you come up, please. Court is calling 2023 CR 10226 State versus Frederica Simone Nelson. Can I have parties announced for the record for the state?
Defendant for the state of Texas.
Defense.
Branch Hardy for the defendant.
And are you Ms. Nelson?
Yes.
Did you understand you're charged with injury to a child or elderly disabled with bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Is there anything you wish to say on behalf of your client?
No, Judge, I don't think so.
All right, so why are you doing this?
When I wanted Emiliana to get down, instead of me pulling her and putting her down like the way I did, I could have did other ways. I could have either played the game with her. We could have
No, that's not what it says. What you're telling me is not what's in this police report. What it says is this child came home from this early learning center. O2 stated she picked victim up from the listed location yesterday at approximately 17:30 hours and found victim crying. O2 stated that victim told her that suspect that she made her cry. O2 stated that she confronted the suspect about the incident and the suspect denied anything happening. O2 stated that she then advised suspect's supervisor of the incident and requested that the video surveillance of the location be checked. O1 stated that the video surveillance was checked this morning and the video showed S1 throwing V1 to the ground. I then witnessed the video that showed S1 sitting on the ground, attempting to clean a cabinet, and the victim was standing in front of her. Suspect then can be seen throwing the victim aggressively to her side and the victim hitting the ground. O1 stated that the suspect was confronted this morning and asked about the incident. O1 stated that S1 told her that she attempted to move the victim by her arm. O1 stated that suspect was immediately terminated after viewing the surveillance. So that's what they say happened. There wasn't I'm trying to stop her from falling. No, it's saying that you threw a child to the ground. And how old is this child?
She was 3. 4.
All right, who throws a 3-year-old to the ground?
So she was on the cabinet, and I wanted her to get down. So I grabbed her and I put her down.
No, they said you threw her to the
That's what I'm
ground.
saying. I didn't throw her down. I took her by her arms and I landed her down. And then I got over her and I told her to get up.
Now, where's the
That's what
video?
I'm saying.
Does anybody want to offer the video into evidence? Does anybody have the video?
Because when the CPS lady,
All right, just 1 second. We're going to see the video. I always say, show me the video if you have the video. Is there any objection to the court reviewing the video?
No objection, Judge.
All right, let's see the video. Review the video. Is there anything else you wish to have for your client?
Okay, so just went to the black screen where it just showed her name on there while she reviewed the video. They didn't show the video on the live stream today. So, but yeah, this was just a couple hours ago. It was interesting court right at the end of the day. So, but no, she didn't show the video.
All right, do you have any children?
Yes,
And what are their ages?
my kids are 26,
Mhm.
24, 21, and 19.
All right, do you have any grandchildren?
6,
And what are their ages?
7, 8, 4-month-old, 3-year-old, and 1-year-old.
All right, and the complainant in this case, how old was the complainant approximately?
3-ish.
All right, so let me ask you this. Do you love your grandchildren? What would you think if somebody did what you did to your 3-year-old granddaughter? Now, I mean, you're saying, yes, I understand, but what do you understand?
But it should never happen.
And from watching that video,
I had no right.
no, right. And from watching that video, what you're telling me is not the same that's in the police report. What's in the police report matches what's in that video. All right. Anything else?
Nothing further, Judge.
Court is going, yes? Court is going to sentence you to 4 years in the prison, suspended and probated for 4 years. There's going to be 90 days in the Bexar County Jail as a condition of probation that starts now. There's a $1,500 fine, time and money to run concurrent. There's to be 100 hours of community service restitution. I'm going to order parenting classes, and I'll deduct 50 once that's completed. And another 50 will be deducted upon completion of anger management classes, and I'm ordering anger management. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release. There's to be no employment as a home health care provider or in the healthcare field or with minors. So you're not allowed to work as a daycare operator. You're not allowed to babysit. You're not allowed to do any of that. And as far as the MRT, I don't think this is really an MRT issue as opposed to an anger issue. And she just shouldn't be working with children. It appears that people are just hiring anybody. Hey, we have a daycare. You want to work here? Oh, yeah, sure. Nobody does any follow-up. Nobody does a psychological. They don't do background checks. They're just letting anybody watch vulnerable people, which I don't understand. Probation, is there anything else she needs? All right. Field visits 1 time per month until further notice. And I'm doing that because you are not allowed to babysit children. Do you understand?
Yes.
And there's to be no unsupervised contact with minors. And that includes your grandchildren. Anything else, probation? Is there anything else that you need from the court to be successful?
Okay, so I need some mental health.
All right.
I was diagnosed with severe depression with psychosis episode.
Okay. We'll do a MIC evaluation in custody and follow recommendations. And, you know, based upon that, that's another reason if you're having those episodes and you're not on medication for it, that's another reason why they should not have had you working at a daycare. But again, people are just letting anybody look after children. I do not understand that. All right, and then we can go off the record in this court to be successful. Communication is key. So you're going to have to work on your anger issues and not, if you see yourself getting angry, you need to count to 10, walk away. You understand?
Yes.
All right, good luck to you.
Okay, this is a statement on behalf of the mother. She said, I trusted you with my daughter and you hurt her. A 3-year-old helpless child, you threw her to the floor like trash. How can someone be so bothered by a child that you choose to hurt them? I will never understand. You will have to live with this the rest of your life, and the plea you're being offered is not half of what you deserve. All these years I left it in God's hands to deal with you, and it's not over. I assure you that, Frederica. I know my daughter wasn't the first or the last. She's just the one who stood up and said something. Thank you, Your Honor.
And so the record can be clear. I think I said time and money run concurrent on the fees, but actually the $1,500 is probated.
Very good.
All right, thank you.
May I be excused?
Yes, you may be excused.
Thanks so much.
You're
Have a
welcome.
wonderful evening.
All right, you too. All right, couple in the red jacket and gray, y'all need to separate that. This is not, Valentine's Day or anything. Oh, that's okay. The love you showing her in court, you need to be showing it on the outside. So when I see you walking outside, you all better be holding hands or something else.
All right, I'm gonna have fun with that mute button tonight. I can already tell. All right, we're gonna do one with Judge Fleischer, and then we're gonna jump into. Hold on a second, the little screens are a little small for me right now, so let me see. Yeah, we got Judge Mogan, so I'm gonna jump into Judge Fleischer, and then we'll go to Judge Mogan there.
Who's junior? And you are the third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, officer dispatched to First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incidents indicating this was possible burglary progress, with fleeing suspects who could have been armed, the officers drew their duty pistol, engaged defendant Love Jr. and several commands to get on the ground and allow him time to comply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both contained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, sir.
Cops never tell them to stop. And what are they doing wrong? I guess, what is this, Minority Report? You know what I mean?
I don't have anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand? Sir. I'm going to find no probable cause on both of your cases.
Thank you, Your Honor.
Take a seat.
Necessary parties. We will go on and can court hear me?
We can,
Clerk?
Your Honor. Thank you.
Thank
Yes,
you.
Judge.
Thank you so much. We will go on the record in the matter 22 CF 87, 22 CF 114, 22 CM 52. State of Wisconsin versus Nicholas Contreras. The state appears through Assistant District Attorney Christian Ness in Washburn County Courthouse. We have Adam Welch appearing by video conferencing with approval of the court. We also have Mr. Contreras appearing by video with approval. This court appears in Burnett County Courthouse by Zoom to Washburn County. We're set here today for the final pretrial in all of these cases. I have received and reviewed the state's request to dismiss 22 CF87 along with 22 CM52. I've reviewed the basis for that request in the fact that the court or the state believes that after thorough review and preparation for the trial, the state believes that they lack further merit and they could not be able to prove to a jury beyond reasonable doubt and prove guilt beyond reasonable doubt in these two matters. First, I'm going to ask the state for a more thorough statement as to those cases, and then I'm going to ask the state if that is applicable to 22 CF 114, which is a felony bail jump. The basis for that felony bail jump is being on the felony bond in 22 CF 87 and being pulled over in Burnett County and operating with after revocation. So therefore, Mr. Contreras was driving without having a valid operating privilege. So Mr. Ness, first off, does the request to dismiss include 22 CF 114?
No, Your Honor. I submitted a request for the two that are scheduled for final pretrials today. I think that the factual basis and the reason for the dismissal is separate from the bail jumping case.
So we're continuing with the jury trial for this felony bond?
I don't believe it has been set for trial yet.
Oh, I'm proceeding with this trial on that date and time.
Okay. My understanding is it hasn't been set for trial. I'm fine.
Oh, no, all of mine are backed up. If one resolves, then it goes to the other one and then it goes to the other one. So this court will proceed with trial on that felony bond case unless the state is telling me it's dismissing it or it's resolved, and that's here today because we have the jury trial set and scheduled already in these cases, and all the time, that is this court's policy. It is always fallback. If one resolves, then we move on to the next case for that jury. And if that resolves, we move on to the next case. So in this court's, in looking at this case and in these cases, we are set to go to trial then on March 25th for a felony bond jump, unless the state tells me here today that it is either dismissing the matter or the matter has resolved.
Understood, Your Honor. I don't object to that. The only reason I did not think that was because the calendaring it has been set for a status conference today and for that date. I don't put it on my calendar that way. I'm not the one who sets it on my calendar, but that's how I work. So if you need time to talk to Mr. Welch to see if it can resolve, we can have a later hearing today since this is our final pretrial, and you can inform the court on whether or not we're going to proceed. But at this time, I am not dismissing any matters until I hear what's going on with 22 CF 114. Well, understood, Your Honor. I don't think that further discussion is necessary. I think that the parties have thoroughly discussed possible resolution. I just don't think that there is a resolution at this time. I could talk more thoroughly about 22 CF 87 and 22 CM 52. In each of those cases, it's the same victim. The victim in both of those instances has requested that the cases be dismissed and has made statements to my office to me, including that because of a traumatic brain injury, she has no memory of any of the incidents that are the factual basis for either of the crimes, and that she would not be able to testify to any of the facts within them. And so I believe that constitutes essential facts under both of the cases. And so without that testimony, I don't believe that I can proceed.
When did she have this traumatic brain injury?
I think she's had this for years, Your Honor.
She's had this for years, and prior to, are we talking prior to these incidents occurring?
Correct.
And from from 2022, from July 27th, 2022, and from July 28th, 2022, up to February 27th, 2025, I'm hearing that the state in no way, shape, or form ever talked to the victim in any way prior to those dates and times, which were going on 3 years, 2.5 years, never from that time spoke to the victim about her TBI and whether or not she would recall any of the incidents and as they occurred or any of the facts. That's what I'm hearing. So I'm hearing that we've had a tremendous waste of resources. Is that what I'm hearing, Mr. Ness?
No, Your Honor.
That's what I'm hearing.
Your Honor, I've spoken to this victim previously. This was a revelation later on in the case. She has, frankly, Your Honor, I'm not certain that I find her statement regarding her traumatic brain injury to be entirely credible. But if an individual is making that statement to me and is indicating that they would not testify to the essential facts of the case, I don't believe that I can call her and expect to prove a case beyond a reasonable doubt.
You still have a duty to subpoena her and call her as a witness, even if she is a hostile witness, and you have the ability to at least try and prove the case, because we are talking, there may be allegations against her. There's a take and drive without consent. There's disorderly conduct. Those are things that you may not need the victim to have full ability to recall and to testify about, correct?
That may be true, Your Honor. I've discussed this with the district attorney. I think it becomes a delicate issue because the public policy consideration is not to treat victims of crimes as though they are criminals. And I think that the forcing a hostile victim to testify and putting the force of the state on them through a subpoena, I think it violates that public policy consideration of my office.
So from July 2022 up until just recently, and I'm going to say, I'll even give you a little bit of credit, last week, up until then, victim was, yep, I'm ready to go. I recall all of these things. Let's go. And then last week or a couple, I'll even give you 2 weeks. She was like, oops, nope, I don't recall. That's how it went down?
No, Your Honor. This happened previously. It has been discussed with, there was a request. I made a statement on the record regarding a witness changing her story. The defense attorney at the time met with me in my office with an investigator. I disclosed what had happened and what was being discussed. There was a proposal for a global resolution as to all cases, and I believed that it was possible to resolve these matters globally on a misdemeanor basis until recently.
And Mr. Welch, there is what I'm hearing, at least from Mr. Ness, and I'm going to not take into account the two serious matters, but to the felony bail jump, there's absolutely no way that this matter is going to be able to resolve and we're going to trial.
It certainly could resolve if Mr. Ness wants to, but there's not a resolution right now.
Because I can give you the day.
I
Because today was my day.
If Mr. Ness wants to talk about it further, I'm happy to talk. If he tells the court that there's no point in further discussions, then we'll have a trial.
Mr. Ness?
Well, Your Honor, my understanding is that the proposal from defense is to plead to misdemeanor bail.
Your Honor, I'm sorry.
Fine.
Sir,
well, and Mr. Welch, I'm going to ask you anyway. I have the right to ask what the offer is. I have the right to reject any offer in the public interest. And if he's saying it's a felony bail and your offer was to amend to a misdemeanor bail, boom, there.
Understood, Your Honor. I just don't want to create a situation where the court's pressuring either side. So
I'm not pressuring any side.
I didn't say the court was. I just was trying to head off that possibility, but I apologize.
My pressure to both sides are we going to continue to use government resources and resources since 2022 until 2025, and then go forward with a trial with a felony bail, which I am fully prepared to do. I have 2 days set aside on my calendar, 2 full days set aside on my calendar which is a lot because I am a very busy court. So I have 2 days on my calendar to have this jury trial. So I just need to know if there's a potential ability to resolve or if we are proceeding in a jury trial fashion.
I think I've made a proposal to the state, and if the state wants to discuss it further, I'm happy to discuss. If the state is just telling us that there's no reason to discuss further, then I'm prepared to go to trial as well.
I don't think that it's likely to resolve, Your Honor. I don't think that there's a point in further discussion.
All right, then we're going to jury on March 25th for a felony bail bond violation case. Everybody's ready to go? So that means I need everything filed. Today was the deadline, but I'll give you a week to get everything filed. I'll extend it to a week since there was misunderstanding as to how this court functions. 1 week. All discovery, all witness lists, all motions in limine, all necessary documents needed for the trial. And we will see you on March 25th. And I'm going to tell you, this is my drop dead date. That means I will not accept any agreement past today. We are done with negotiations. We're done with resolutions. That means this trial will proceed. The only way it will not proceed as a trial is if Mr. Contreras pleads guilty to the charge. Whatever the resolution is, that's for argument's sake and for whatever can be negotiated. But with regards to that, either he pleads to the charge or the state dismisses it. But we're going to trial March 25th on a felony bond violation. Because we all have that day set aside. Court has it set aside. I have it set aside. Mr. Contreras has it set aside. And it is in the public interest to keep this matter moving. It is a 2022 case. We are now in February 27, 2025. Do we have any questions?
So, Your Honor, is the court signing the orders then on the 2 other cases?
Well, if I'm hearing from the state that they, from July 2022 until February 2025, had no idea that the victim had a TBI and had an ability to recall certain facts and would not make a good witness, and they can't prove their case. And it's been going on for this long and using all of these resources. I guess it's kind of a quandary for the court. I can't force a trial upon a victim who would be put through the ringer, and quite honestly, a defendant and the public justice system. Resources have already been wasted. So I will sign those 2 dismissals, and I will see you for jury trial for the felony bond jump violation. And with regards to that case, what I'm going to do is I have cash on the other matters. I'm transferring that to 22 CF 114. I'm making sure that the bond is applicable to 22 CF 114. It is. It looks like it's filed in 22 CF 87, and it says the bond to cover all of the cases, same conditions as previous bond. So same bond, same conditions, same cash. We will see you March 25th. Be ready to go.
Will do. Thank you.
Thank you.
Ali, I had the same question. I didn't know what it was. Let's jump to Judge Simpson. Let's go to Judge Simpson here.
Or calls the case, recalls the case, People versus Sean Courtright. You're leaving for the day? Come here for a second. Counsel, approach. You better bring a supervisor because you're in trouble. I can work with you on everything that I've tried to work with you on.
I had just got out of jail. I didn't have money. I don't have money for that. If I go to jail, I'm going to lose my housing. I've been kicked out of therapy. Everything that it was helping I've been kicked out of. I'm not able to attend my women's trauma group because I had court Wednesday. I had just got that started back after a year. I see my baby. I haven't seen her in 6 years going through this court stuff, them sending stuff to the wrong address. My baby gonna be 18. I don't have a natural parent child bound
Every
with my
case
daughter.
before me, I've tried to work with you. I have.
I'm just not getting
appearing
paperwork.
on certain things. I've done everything I possibly can to try to facilitate the process for you.
If somebody
But I
pays
can't,
for it, I don't
if you
have.
want to keep interrupting me, you can keep interrupting me, but it's not going to get you. But the cold-hearted reality is that when you're given bond conditions, you have to comply. You can't just go over there and say, I'm not going to do it.
I didn't say that. I called my attorney and spoke with him and voiced my concerns with that. I'm physically not able to do that. I have issues, health issues with that.
Well, it's going to have to be
And
addressed.
I can't
Judge Valvo
physically-
regarding her release. Defendant's bond is revoked. She's remanded to the Washington County Jail.
Excuse me, I'm gonna lose my housing, like, my rent and stuff is due. Well, can we talk again? Because I didn't talk about this with you, Mr. Lucas. I got rent coming up. I'm gonna lose my housing. I can't see the daughter. What is this about? Like, what did I do? Please say something before I come back.
All righty then. 14A will stand in recess. All right. Court does call the case of the people of the state of Michigan versus Tomika Slip.
Hi, Mr. Simpson.
Good morning.
How are you?
I'm fantastic. And you?
I'm good. Did you have a good Christmas?
Yeah, a while back I certainly did.
Me too.
And you?
I got a Christmas present.
Yay.
Somebody
got one.
crochet me a teddy bear.
Oh, fantastic.
Yeah, I loved it. And cuddle with it every night. Its name is Brown Bear.
No relation. Not going there.
And
No
you still
relation.
got that beautiful smile. You still got that beautiful smile.
Andrew Children's a great on behalf of you.
Warren Brown.
Nice of you to finally speak up. Go ahead.
Warren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Schlick, who has already introduced herself.
Yes, she has.
So this is a you hearing. We don't have any updated.
Our office received a report.
I have a date. I have a report received February 19th, dated February 11th. Is that the one you're referring to?
Yeah, I checked our materials. As of yesterday, we haven't received it. We just got it yesterday. We received it yesterday, yeah. It's competent. That's right. Okay. So the finding is that my client is competent to stand trial. In which case, Your Honor, since we've had a chance to review that, has the court received that same report?
I haven't reviewed the same.
We have no further evidence.
All right. Any other evidence from the people?
Nothing on behalf of people, Your Honor.
All right. The court would find, based upon that report, that the defendant is competent to stand trial. Specifically would indicate that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. And so the defendant is therefore deemed competent.
Thank you, Your Honor. We will tender a finding and order to the court this afternoon. At this time,
I'm going to need 5 orders.
5 orders for 5 cases. Yes, sir. So at this point, we will to adjourn so that we can do a probable cause conference.
All right.
I think 2 weeks is the minimum you'll need.
Yes. All right. So probable cause conference will be set for March 13th.
March 13th.
2025.
Did that mean I come back to court on the 14th?
Yes, ma'am.
And we'll talk to you in between that time.
We'll see you in a couple weeks.
Okay, I'll see you later, Mr. Cedric Johnson, the new one.
All right, bye.
My mama watches your podcast.
Okay. Yes, ma'am.
Bye-bye.
All my clients are that happy to see you.
I know. Yeah. It's nice to have somebody happy.
Sorry.
All right, take care.
Miss, can I go?
Yes, you can go.
You have a great day. Have a great couple weeks. See you in a couple weeks. Bye-bye.
You too. Court calls case People versus Maris Hanky.
So that goofy girl, imagine the hell she probably caused to get put in jail. Imagine how much of a hellraiser she was and out there with that voice, and then she gets put in jail and just as nice as could be. It always amazes me how nice some of these people are once they're in jail. So here we go.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Maris Hanky. Mr. Hanky, state your name for the record.
My name is Maris Hanky.
All right. And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine, when appropriate.
Adjourned matter March 13th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say, but.
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located. And they stopped supervision. I also wanted to address his jail before he got out.
And you're aware of this?
I am, Judge.
And I also wanted to address his jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name, I can't tell you, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defendant says, y'all been talking, right? He says, no, I've only been talking to Keita, who's the victim. He says, can't see that name on the phone, because she's my case. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he would be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well at a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
Absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hanky, he's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittingly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it, honestly, Judge. And if hear me out, Judge, I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor, I would.
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSE fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge, community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that his the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. There was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have this bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught. And
we would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case, and I'm just asking for a second chance.
Counsel, go ahead, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And then on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Kia, who is the victim?" he goes, "Don't mention her. She's my case." So I have great concerns that he would still be violent.
He's playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked, defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with the bond at that point, but right now he's remanded.
Thank you, Judge.
Thank you.
All right, we got Judge Shackelford next. We're gonna jump over there. A few people made Simpson laugh, made Simpson mad. Seems like a good day in Simpson's court. So here we go, Judge Shackelford.
Right, Mr. Chandler's here, Ms. Pescucci's here. Can you unmute? This is 25010326. Leon Chandler and Renee Chandler versus Kristen Pescucci. Mr. Chandler, can you tell me your name? You're muted. We'll get you going.
Yeah, this one apparently has.
Ma'am, you have to get off the phone. Like I'm literally, you're in a courtroom. All right.
Guys, I'm on the phone with my grandmother, the homeowner.
Okay. Which one of you is Kristen Pescucci?
Me.
You are. Okay.
Yeah.
All right. Mr. Chandler's here. Mr. Chandler, tell me your first and last name. You need to unmute. I'm asking you to unmute. Got it? Good. Yep. Tell me your first and last name.
Leon Chandler.
All right. And Ms. Pescucci, can you tell me your name? I'm sorry if I'm butchering your last name.
It's okay. It's Chris Pescucci.
All right. So we're here today. There was a dismissal that was filed,
Right.
and then there was a motion to set aside the dismissal. So we're here today. Where is Renee Chandler?
She's on the phone. That's actually who the person next to me is talking to.
All right. Well, where's Renee Chandler at, Mr. Chandler?
She's in the house.
Well, wait 1 second. Mr. Chandler, where's Renee Chandler?
She's in the other room. You want me to get her?
Yeah, you two both have to come into court. It's both of your motion. So she doesn't need to be on the phone with the other party. She needs to be in the courtroom.
Okay. Just a second.
Yeah, now's your chance to speak up.
That phone can be hung up. She's coming in.
Yep. She's coming in right now. I'm not gonna.
Yeah.
All right, if you can just sit by her, Mr. Chandler, so I can see you both.
Okay.
All right, ma'am, can you tell me your first and last name?
Renee Chandler.
All right, thank you. All right, so we had a motion that was filed. Originally, there was a demand for possession of the house. It was a termination of tenancy, essentially, and then it was set aside. The case was dismissed.
Right.
And we had notice of dismissal that was signed by Renee Chandler. And then we had a motion to set aside the dismissal. So Ms. Chandler, you and Mr. Chandler, do the two of you, can you raise your right hands? Both of you? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, do you, the two of you own a home together?
Yes.
All right, and where is the home that you own? Is that the one on Holland?
Yes, ma'am.
Do you also own a home on 2 Lane?
No.
No.
Okay, so the home that you own and that is that issue in this case is the property at Holland.
Right.
Okay, and does Miss Pascucci still reside there?
Yes.
At this moment.
Okay,
Yeah.
so she's still living there. And so this motion to dismiss the case was filed. Mr. and Mrs. Chandler, is it your position at this time that you want to go forward with the termination of tenancy?
Yes.
Ma'am?
Yeah.
Okay, so they want to go forward.
Mamie,
with that.
No.
Don't.
Mammy, she's asking if you want to evict us. You're lying. We have you on video. We have you on recording. You know that.
Ma'am, Miss Gucci, you're in a courtroom. Okay?
I'm sorry.
Okay, act like it. Miss Chandler. So this suit was originally filed. I'm understanding that this is your granddaughter. Is that correct?
Yes.
All right. Are you feeling
Oh,
pressure?
no, I'm sorry. Excuse me, Judge.
Yes?
No, it's not my granddaughter. It is
My granddaughter's friend.
my granddaughter's friend.
All right, Miss Pascucci. So she's not a family member. She's just someone that's residing at the location with your granddaughter.
Yes.
What's your granddaughter's name?
Logan Renee McNutt.
All right. Now, Mrs. and Mr. Chandler, is it your testimony to this court that you want Miss Pascucci to vacate the residence?
Yes.
Ma'am?
Yes.
Shh. Who is talking back there? She's not. Miss Chandler, would you like Miss Pascucci to leave the property?
Yes.
Okay, Miss Pascucci, you don't have an ownership interest. You're there as an at-will, tenant, and they're asking for you to vacate the property.
Yes, I didn't know that they were asking me to vacate the property. They actually never asked me to vacate the property. Eviction notices.
Well, they did because they filed these notices that there were threats against family members. It was causing havoc. And that it's happened, on more than one occasion.
Excuse me, miss. I'm not sure what your name is. I actually stay outside.
My name is Judge Shackelford. I'm the judge.
Okay.
Okay.
Yes, ma'am. I stay actually outside on their property in a trailer because I'm actually homeless. I'm trying to find somewhere to go. They know that. That's the only reason that I'm actually here. I don't even really go in their house unless it's to shower or to cook. But I actually bought a burner from Family Dollar to be able to cook my food out here. So I don't have to use the bathroom in the house either. I bought a bucket with some trash bags. So I don't even have to go in their house.
I know, but you can't, Miss Pascucci. I'm sympathetic to your circumstances, but that's their property. And it's their home. And if they don't want you there, you can't stay there.
Leon does not. I have voice recordings of her saying that.
I don't care. She's in court. She's under oath. She's advised me that she wants you to vacate the property.
Under oath, ma'am.
Okay, you have to vacate the property. You have 10 days to vacate.
More than that, I don't have a job right now. I need
All right, ma'am, this is the law.
I understand.
And I don't, okay, well, I want you to understand that's the law. You have 10 days. I can tell why they want you out because you think you can talk over people and yell. You have 10 days to vacate the property. Mr. and Mrs. Chandler, you are to call police.
That's not fair. That is not right.
You are to call police if she tries to vacate or if she tries to enter your premises, if she tries to come in your home, and if she does not leave in 10 days, you come up to the court and there is a form that you get for a writ of eviction, and our court officers will come and remove her and all of her belongings from the property.
Okay,
But
Judge.
Mr. and Mrs. Chandler, if she comes near you or her granddaughter attempts to convince you otherwise, the two of you are to call the police forthwith. You're to call the police. They're not to harass you. You have no obligation to keep anyone on your property that you're not comfortable or safe with. She's to remove all of
and
the property.
It's just him. He steals from her and everything else.
She's to leave your property. And you're to contact law enforcement if she comes. Do you understand me, Mr. and Mrs. Chandler?
Yes.
Okay, I'm signing it. You have 10 days. You can get your writ for eviction in 10 days.
This is so not fair.
You know what, Ms. Pascucci, do you pay rent even? You want to just stay on someone's property for free and you think that's not fair? That they want you out?
That's not even it, ma'am.
All right, I think she might be a risk to your safety, Mr. and Mrs. Chandler. She clearly cannot control herself. The allegations, Mr. Chandler, Mrs. Chandler, who's that? Who is that behind you? Mr. and Mrs. Chandler, who is that at the door behind you?
That's
Your granddaughter?
No.
Yeah.
My granddaughter came in the bedroom just now. And she's
All right,
arguing
and she,
with my-
Miss Pascucci's to leave the property forthwith. She's a threat to your safety, her and your granddaughter.
Okay.
Ma'am, you're to vacate the property forthwith. I find that you present a risk to these two individuals. It is unsafe for you to be at the property. She's to leave forthwith. I'm signing an immediate writ for her eviction.
Yeah, I'm sure you are.
I am. And you know what else? I'm going to hold you in contempt if you say one more word. Mr. and Mrs. Chandler, do you need to have your granddaughter vacated?
No, we can handle my granddaughter.
Okay. She's to leave the property immediately. I'll sign a writ now.
Okay.
Okay?
If
she comes in your home, if she makes any threats towards you, if she does not leave forthwith, you're to call the police.
Okay.
Are we clear?
Yes, ma'am.
All right, she's to vacate forthwith. I'll have the clerk bring up paperwork. Mr. and Mrs. Chandler, you can come up to the court and get your writ today. I need to fill that out. Okay, come on up to the court.
Okay, thank you.
All right, thank you. Okay. Is that her screaming in the background?
Yeah, it's okay. That's my granddaughter.
Okay. It's just your granddaughter screaming. It's not
Right.
the other individual?
No, the other individual is not in the house.
All right. What do you do if she comes in the house?
We ask her to leave or call the police.
And yes, sir. All right, you're all set. Have a good day.
Okay, thank you, Judge.
Yeah, all right. Mr. and Mrs. Chandler, are there any further issues? Has she?
Okay, thank you.
Hey everybody, that was a fun one there. We're gonna jump over to Judge Simpson from today. He had a landlord docket on today, so let me see if this is Judge Simpson.
Our $J Group Holdings versus Azar Segdahi Safel. So, what was that?
Ready, Your Honor.
Good afternoon, Your Honor.
And where are we on this?
May I pass to the bailiff to hand this to the,
What is it?
this is the petition for joinder before federal court we filed, Your Honor.
The petition for joinder?
Yes. We amended the complaint and we added R&J holding to our federal complaint in US court.
No. Have you seen that?
I have not, Your Honor.
Well, you can't just give me things and expect the court to take them without showing opposing counsel.
Okay, I have a copy for him. He refused to accept.
Your Honor, she hasn't tendered it to me. Also, for what it's worth, yesterday at about 11 o'clock in the morning, the defendant served upon my office a ream of pleadings, responses, motions to stay, motions to dismiss, and so on. And I did my best.
For what case? For this one?
For this case. We're not a part of that federal case. And she is doing the classic attempting to turn this into a federal case when in fact it's just a summary proceedings action, Your Honor.
Absolutely not, sir.
And I did also give her copies of everything I filed by overnight mail and today. I handed it to her a while ago and she gave it back to me. I'm not going to fight over it, but they served me with a series of motions. I had to respond.
I don't have any motions.
No.
Yes, Your Honor, the package in front of you has a motion to dismiss, has petition for a stay, has answer to the complaint. and
Okay,
has a
you filed
counter
these
complaint.
today? Yeah.
No,
today.
we filed it yesterday, Your Honor. You only gave us a week to answer. Remember, Your Honor?
Your Honor, you gave her.
Oh, ma'am, I remember everything I do. Do not try to address me that way. I will have a memory that will throw you in circles. So don't come at me like that. Because if you come at me like that, you're going to get hurt.
I respect.
Counsel, what were you saying?
Your Honor, I was saying that as I recall, and I wouldn't challenge your memory, you may as well, when we were appeared and she asked for the opportunity to present some reference to this federal case, you said, we're going to adjourn this till next Friday at 3, and you can deliver to me a copy of that federal case so that I can look at it, not file a whole host of other pleadings and other matters at the last minute. I mean, that was tough for me to handle, but I got it out, Judge.
Well,
a copy of federal pleadings is part of that package that was hand delivered to this gentleman and to the court, Your Honor.
We have nothing to do with that federal case, Your Honor, at this point.
No,
She
you
has a
do.
case against Wells Fargo, who was a prior mortgagee in the case. We have nothing to do with it whatsoever. We're the deed holder of the property.
there's also been a parties added.
Which they counterclaimed against us yesterday at 11 o'clock in the morning and filed several motions. No parties have been added to this case, but she says she wants to add us to that federal case, and I
Well,
encourage.
the caption is changed.
Correct.
You can't just change the caption.
Well, we haven't been served, and I got the document.
Counsel, I get it. I'm just saying, this caption that I have on your documents is not the caption of this case.
I'm sorry?
The caption here, who is Carl Stafford?
Carl Stafford is here. He's my.
I don't care if he's here. He wasn't a party to this case, was he?
No.
It says all residents of the house, and he's the resident of the house.
You can't just change the caption.
What do you suggest I do, Your Honor?
You don't want to hear that. I suggest maybe you get an attorney because I just don't.
She is an attorney, Your Honor.
Well, that's even more alarming. I don't even know what to do with this because the caption has changed, right?
Yes.
You served motions and apparently there's a counter complaint that the other side or whoever was supposed to add doesn't have an opportunity to answer. I don't even know if there's been a summons issued for these other parties.
Yes, there has.
Are you an attorney?
I'm not a bar license holder attorney. I went to law school.
Counsel, you filed an amended complaint, correct?
I did, Your Honor.
All right.
We have not received that.
I gave it to her.
No, we have not received, sir.
I gave you the packet and you gave it back to me.
When was that,
Just
sir?
now, I gave it to
You
your
gave
husband.
it to me
You
now.
want to have your own darn conversation. You can do it outside. You don't need me here. I'm not going to be a third wheel on a date in my courtroom.
I'm sorry, Your Honor, very sorry. I did give her all of those pleadings and the amended complaint in a white envelope, which she handed back to me.
Did he give you an envelope and then you give it back?
Yes, because
Why?
because I tried to give him the joinder and he gave it back.
She never handed it
This is
anything.
like this is like kindergarten. I'm going to accept the first amended complaint, counsel. You can serve it on her in whatever way you wish in terms of either you can do it by email or you can serve it by first class mail. If she won't take it, she won't take it. What you filed, which starts out entitled plaintiff's defendant's answer to the counter. You're going to have to refile this. I'm striking this pleading. You can't just change a caption. Well, guess we're done. And so I'll give you a week to get that out. I realize it delays the proceedings, but I don't think I can do anything else because I don't know why these parties are running around in this case that you just added to this as the petition to stay is filed on this is crazy. You're gonna have to start over. I'm striking all of that you filed. And you're gonna have to just do it right. I'll take yours, you serve it, they'll have to answer, and then we'll go from there. I don't know that putting it out to next week is gonna do us any good, so I'm gonna put it out to the 14th.
Thank you, Your Honor. I would ask the court if it may. She hasn't paid rent. They haven't paid rent since November. The rent for November, December, and January is $5,000 a month. And the rent for February and March is $5,500 a month. I would ask that you ask them to escrow.
What is the current monthly amount of rent?
It's there's a holdover provision, but we'll accept the normal rent, Your Honor.
About 5,000.
5,000 for.
I'm going to order escrow.
Escrow, we would pay it in escrow, Your Honor, but not to them because they have to sell the property to us.
I'm going to order that you pay escrow to the court in the amount of $5,000. I'm not going to do a proration back to the original. You'll start that March 1st. It needs to be paid within 7 days of the date of my order, and then needs to be paid each month while this matter is pending. Do you understand that?
Yes, Your Honor.
Please
Thank you, Your Honor.
Order to that effect. I will adjourn this.
February rent and March rent?
I can only have March rent.
March
I
rent.
could prorate a day February, but
That's not necessary. We'll accept the
March 14th, 2025 at 1 p.m. I feel a cold coming. 1 p.m.
You're on. Have a nice weekend.
Yeah, I will now. All right. Now give it. Yeah, give it because Ann.
Can I take it?
Can you what?
Could we submit the joinder or no?
You may, if it is in proper form, submit it anything that you like, but not to me.
Okay,
You can file it with the clerk's office once the file gets up there.
by all means.
Just don't. Just don't. Just
Are we dismissed, Your Honor?
bye. Yes.
Thanks, Judge.
So I think this was a business property. I'm almost certain it was business property. That's $5,000 a month. They've been in the hearings a few different times, and I'm just gonna stick with it being a business property. This is Nicole Murdoch. I didn't hang around long enough to see her. She certainly don't look happy. That's gonna be it for us tonight. Thank you guys so much for coming out. We'll see you tomorrow morning with Judge Fleischer. If he comes on, we'll be there. And you all have a great night. Let me find the right thing. If I don't do the credits, y'all get mad at me. So here we go.